Court officer, court officer. Serial number 32, my lords. I am for the appellant, my lords. I inform the other side, my lords. 32, my lords. Behalf of Ajay Kumar AK. Serial number. Next week, any date. Fifth. Fifth.
Contractors filed a suit for recovery.
Fifth. Fifth, my. Public.
ಮಂಡೇ ಅವ್ರೇನಾ ಪ್ರಕಾಶ್ ಮೈಸಲ್ಗೆ ಏನೋ ಬೇರೆ ಕಡೆ ಹೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲ, ಇದು ಸಂಜಯ್ ಜೋಶಿ ಅಂತ ಓನರ್ಗೆ ಅಪೇರ್ ಆಗ್ತಾರೆ. ಸಂಜಯ್ ಜೋಶಿ ಅಪೇರ್ ಆಗ್ತಾರೆ ಸ್ವಾಮಿ ಕಂಪನಿಗೆ. ಅವ್ರೇನೋ ಮಂಡೇ ಸಂಜಯ್ ಜೋಶಿ ಅಪೇರ್ ಆಗ್ತಾರೆ. ಮಂಡೇ ಕೇಳಿದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರು ಮಂಡೇ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ. ಪ್ರಕಾಶ್ ಮೈಸಲ್ಗೆ ಜೂನಿಯರ್ ಮಂಡೇ. ಹಾ,
ಅಶೋಕ್ ಮುಳಗಿ. Pronouncement of judgment, CL number 1, MIL Kulkarni. Order CL number 2, additional SPP. CL number 3, Jidege Kailasi.
Which time may be granted to file the all additional documents, the test reports and medical bills. Our test reports, medical bills, ಎಲ್ಲ ಇಲ್ಲೇ ಇದಾವ ಮೇಲೆ ನಮ್ಮ ಜೊತೆಲಿ ನಮ್ಗೆ ಕೊಟ್ಟರೆ ಅವು ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿ ಐ ವಿಲ್ ಫರ್ನಿಶ್ 1 week time ಮೇ ಬಿ ಗ್ರಾಂಟ್. ಈಗ ಇದು ಕ್ಲೈಮೆಂಟು ವೇರಿಯಸ್ ಟೆಸ್ಟ್ ನಲ್ಲಿ ಅಪೇರ್ ಆಗಿದ್ದಾನೆ ಅವ್ರ ಬಲ್ಲಿ ನೀವು ಅವ್ರ ರಿಪೋರ್ಟು ಮತ್ತು ಬಿಲ್ಸು ಎಲ್ಲ ಇಲ್ಲೇ ಇದಾವ ಮೇಲೆ ನಮ್ಮ ಕೈಲೇ ಕೊಟ್ಟಾರೆ. ಅದಕ್ಕೆ ಇಲ್ಲ, ಅದು ಅವ್ರು ಇಲ್ಲ ಸರ್, ನಾನ್ ಹೇಳ್ತಾ ಇರೋದು ಅವು ಟೆಸ್ಟ್ ಮಾಡೋದು ರಿಪೋರ್ಟ್ ನಮ್ ಜೊತೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವು ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ ರೀ, ಟೆಸ್ಟ್ ಅವ್ರದ್ದು ಒಪಿನಿಯನ್ ಬಂದಿದೆ ಮೇಲೆ ಟೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡದ್ದು ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಇವ್ರಿಗೆ ಏನು ಬಿಫೋರ್ ಎಕ್ಸಾಮಿನಿಂಗ್ ಈಗ ವೇರಿಯಸ್ ಟೆಸ್ಟ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಆ ರಿಪೋರ್ಟ್ ಹಾಗೆ ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಹಚ್ಚಿ ಅವು ಬಿಲ್ಸ್ ಇದು ಹಾಕ್ಲಿಕ್ಕೆ 1 ವೀಕ್ ಟೈಮ್ ಕೇಳ. ಹೌದು ಹೌದು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ. ಇಲ್ಲ ಇದರಲ್ಲಿ ನಾನು ಅದ ಹೇಳ್ತಾ ಇಲ್ಲ ಮಿಲಾಡ್. ಈಗ ಅವರು ಈ ರಿಪೋರ್ಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಇದು ಟೆಸ್ಟ್ ಏನ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಆ ಟೆಸ್ಟ್ಗಳೆಲ್ಲ ನಮ್ ಜೊತೆಯಲ್ಲೇ ಅವ್ರಿ, ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿ. ಅದಕ್ಕೆ ಅವು ಹಾಕ್ಲಿಕ್ಕೆ 1 ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಮೇಲೆ. ಒಪಿನಿಯನ್ ಅವ್ರದೇ ರೀ. ಈಗ ನಾವು ಈಗ ರೈಲ್ವೆ ಟಿಕೆಟ್ ಹೋಗೋದಾಗ್ಲಿ, ನಮ್ಗೆ ಅಲ್ಲಿ ಖರ್ಚಾಗೋದಾಗ್ಲಿ, ಮತ್ತೆ ಮೇಲಾಗಿ ಏನದ ಇವು ಟೆಸ್ಟ್ಗಳಾಗ್ಲಿ ಇವು ಹಾಕೋ ಸಲುವಾಗಿ ನಾನು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. 1 ವೀಕ್ ಅದರಲ್ಲಿ ಅಂದ್ರೆ ಡಿಟೇಲ್ ಆಗಿ ಬರ್ದು ಹಾಕ್ಬೇಕು ಅಂತ ಉದ್ದೇಶ, ಮತ್ತೇನಿಲ್ಲ. ಹೌದು ಸರ್, ಅದೇ ನಾನು ಮೇಲ ಅದನ್ನೇ ಈಗ ನಾನು ಬೆಂಗಳೂರಿಗೆ ಹೋಗಿ ಅವ್ರ ಬಳಿ ಟೆಸ್ಟ್ ತಗೋಬೇಕಾದ್ರೆ ಅವೆಲ್ಲ ಬಿಲ್ಸ್ ಅದೆಲ್ಲ ನನ್ನ ಕೈಲಿಂದ ಕಟ್ಟಕ್ಕೆ ಹಚ್ಚಿದ್ದಾರೆ ಮೇಲೆ. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಫರ್ನಿಶ್ ಮಾಡ್ಬೇಕಲ್ಲ. This is injured. ಮಂಜುನಾಥ್ ಕೋರ್ಟಲ್ ಫೈನಲ್ ಇದ್ದಾರೆ. ಕೋರ್ಟಲ್ ಫೈನಲ್ ಇರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕೋರ್ಟಲ್ ಮಂಜುನಾಥ್ ಅಂತ ಹೇಳ್ರಿ ಅಮ್ಮ, ಚಿದ್ರಿ ಅಂತ ಹೇಳಿ ಅವರೇ ರಿಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ ಮೇಲೆ. ಮಂಜುನಾಥ್ ಚಿದ್ರಿ ಅಂತ ಹೇಳ್ರಿ, ಉದಯ್ ಹೊನಗುಂಟಿ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಉದಯ್ ಹೊನಗುಂಟಿ.
CL number 4, Sudarshan.
Please. My lord, in this case, my lord, for R5 is, my lord, owner of the vehicle. My lord, we, my lord, pay PF, my lord, during the course of the day today. Yes. Published. Lord, there is a, my lord, a direction, my lord, it is a matter of pay and recovery, as my lord, the driving license, my lord, the driver of the vehicle not holding as on the date of accident. And my lord, accordingly, my lord, the court has made an observation, we should pay it and then, my lord, think of, my lord, recovery. And that's how, my lord, I will, my lord, suggest the, my lord, officers to deposit within 4 weeks. And will, my lord, come back on, my lord. My lord, on 6, please. Not issue, my lord, not, no, my lord.
You are seeking extension of time.
Extension of time. My lord, but there is no interim order in this matter also. Interim order is not granted. Only, my lord, depositing, my lord, I am requesting. Others. Yes, please. 6/4/2023. What my lord has observed is right. There is no, my lord, timing mentioned in this. And my lord, we in fact, probably there may be in confusion, they deposited in, my lord, other matter. There are, is same accident. Two cases. So this also I will suggest them to, my lord, deposit within 4 weeks. So, my lord, kindly, my lord. It is really. Okay. No direction.
And they're satisfied. When it comes to the exponent, that in the connected matter, the appellant is satisfied, the claim of direction units. So, however, though in this manner, specific direction of the the appellant to satisfy the award. No, the appellants have not deposited set up. The appellant that the direction will be complied in a period of 2 weeks.
Please, ablished. Please. Much.
CL number 5, MIL Kulkarni.
My lords, there was an undertaking given by them on 12/11/24, my lord. They had sought for 2 weeks' time for the compliance minutes. AAG had appeared and he had requested, my lord. Till today, no action was taken. That was no, my lords. Last occasion also it was listed.
Connected, serial number 11 also connected, my lord. Review petition is dismissed already.
7/11 dismissed, RP is dismissed. And WA, my lords, have already expressed.
Last occasion AAG appeared and
We sought time, my
assured that
lords.
they will comply with the order. After dismissal of the review petition,
Yes, my
supermarket.
lord, supermarket.
Allotment of all
And now they are
process.
telling that writ appeal is filed. My lords, may kindly turn to. Yes, my lords. 12/11/24. He'll held. He'll there.
Yes. ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
Sir, mute ಆಗಿದೆ. Unmute ಮಾಡ್ಕೊರಿ. Yes.
May I make a submission, my lord, with lordship permission?
Yes.
My lord, in this case, my lordship is completely aware this, we have no case before this honorable court, my lord, on merit of the case. And we have been, we are in processing of this,
Your writ appeal was dismissed, your review petition was dismissed.
I agreed, my lord, and we have no options, we have to be, comply the directions of this honorable court. My lord, in the meantime, my lord, this, the allotment concerned this site also, it's required to be in, the survey is, it is under the process, my lord.
ಏನ್ ಸರ್ವೆ?
ಅದು allotment site ಗೆಲ್ಲ ಯಾರ್ಯಾರಿಗೆ ಏನೇನು
ಅದಕ್ಕೆಲ್ಲ ನಾವು
ಕೊಡೋದು
ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು ಲಾಸ್ಟ್ ಟೈಮ್.
Yes.
it is not completed, my lord, it is not.
11.
ಒಂದು
We had given you more than 2 weeks time.
Correct, my lord. So we are in the ಇದು process ಅಲ್ಲಿ ಇದೆ, ಇದು ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಮಾಡ್ತೀವಿ ಅದನ್ನ. ಬಂದ ತಕ್ಷಣ ಯಾರು ಏಲಿಯನ್ ಸೈಡ್, ಯಾಕಂದ್ರೆ ಮುಂದೆ ಶುಡ್ ನಾಟ್ ಬಿ ಎ ಡಿಸ್ಪ್ಯೂಟ್ ಆಲ್ಸೋ. ಸೊ ದಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಬಿ allotting as per their applications is concerned, and the priority basis it is on the process, my lord. The one accommodations is required. We have no options. We have to undergo this directions of this honorable court only, and we have no case also before this court now. And it is in the process, my lord. The short accommodation, my lord. The situation is beyond control. Some various reasons, which I can't express before this honorable court, my lord. I unconditional apology for embarrassment situation before the lord. Sorry.
Additional advocate. that although he had made submissions on the previous occasion, that sometime would be required to identify the sites for allotment to the complainants, and had sought for 2 weeks' time. Come on, nevertheless, the process is on, and within a short time, the sites will be identified and allotted to the complainants.
And identify, my lord, thereafter, with the lordship permissions, before this court only, we are going to be clarified, because it should not be litigations, my lord. Or to identify, we'll submit to the paper, submit to the court.
Want to brought to the court, my lord, already it is division is made and they identified the plots also.
Before this court has to be a
Yes.
submit, so that the once court order in future, no.
ತಗೊಂಬನ್ರಿ, ಅದನ್ನೇ ತಗೊಂಬರ್ಬೋದಾಯ್ತಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ.
24
is in the
23
process.
itself, it is, division is made, my lord, they have identified the plots also.
Next, at this juncture, learned counsel, ಏನದು?
The division of and identified the plot and goes to 20 into 40.
Learned counsel for the complainant submits that a communication has been made by the Commissioner of the Urban Development Authority, Kalaburagi,
To execute engineer. Map is also available.
ಅಲ್ಲ ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್ ಅಂತ ಏನು ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ.
That's only for the allotment of this situated supermarket Kalaburagi.
ಎಲ್ಲಿದೆ ಹೆಂಗಿದೆ ಎಲ್ಲೂ ಇಲ್ಲ.
Yes, permission is
Permission is
granted,
hereby
granted
granted
under section 70.
for subdivision, come amalgamation of commercial plot so and so situated in supermarket ಅಷ್ಟೇ ಹೇಳಿರೋದು.
Yes, ma'am.
ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್, ಯಾರು ಅಟ್ ಹೂಸ್ ರಿಕ್ವೆಸ್ಟ್ ಏನು ಇಲ್ಲ ಇದರಲ್ಲಿ.
And the sketch is also prepared, ma'am.
My humble submission to a lordship, my lord, if it is a records unnecessary, it should not be create the problem. My prayer, my lord, the short accommodation may be granted, my lord, that it will be get clarified, ma'am.
Yes. ಏನು to on 24/11/2023 to the executive engineer of the PWD department, Kalaburagi, granting sanction.
Plot number is also mentioned, ma'am. That is
Under
our,
section 17 of the Karnataka Town and Country Planning Act for subdivision come amalgamation of commercial plots number 376 and 377 situated at the supermarket, Kalaburagi. Full stop. It is submitted. The said orders have been passed at the request of whose request?
Serial number 11 ನಲ್ಲಿ petitioner. The claimant,
Claim
the
serial
complaints
number
are serial
11,
number
madam.
11.
Huh?
serial number 11, madam. It's our plots. 376 and 377 are both are the.
ಅಲ್ಲಮ್ಮ, ನಿಮ್ಮ ರಿಕ್ವೆಸ್ಟ್ ಅಲ್ಲ. See, a request must have gone from the other authorities.
Yes.
Public Works Department ಅಂತ ಹೇಳ್ತಾರೆ, Executive Engineer, Public Works Department. At the at the request of the respondents herein to enable allotment of sites to the complainant. Full stop. Next para. If that is so,
After completion of this contempt
if
proceedings.
that is so, the respondents are required to proceed expeditiously to allot the
Intercept.
sites. Full stop. For that purpose, release this matter on 5th of December.
Please.
Yes.
Let there be an understanding that at that time they don't buy that time.
Huh?
Malad,
Let there be an understanding that at that time again they won't come up because last time they have said
Next
they would.
para.
be-
If allotment is not made by the next date of hearing, the deputy commissioner,
Please,
the deputy commissioner Kalaburagi shall be present before this court on the next date of hearing.
grateful.
Malad, instead of 5th, my prayer, kindly have it in 9th, Malad.
ಆಯ್ತು.
Malad,
ಆಯ್ತು.
Ninth.
Ninth.
9th, much only. Great.
Serial number 11 also same.
11.
Same. ಇದು ಕೂಡ same.
7, other 11 ದಲ್ಲೇ they already division has been made and they forwarded to the executive.
ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲಮ್ಮ, ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. That is why we have recorded that. Let us see what they will say.
Same.
Same.
ಅದು ಕೂಡ same.
Same order. Connected.
Serial number 6. Jagdish.
I'm for the complaint, Your Worship.
Lord, in this case, I undertake to file power for respond number 2 and 4, my lord. Yesterday, the police has served the notice 2 and 4, my lord.
My lord,
And,
last time this court has directed whether the complainant is relieved or not. My lord, kindly see the orders copy. My lord, they relieved me from the post, Your Worship. By way of annexure D, Your Worship. They joined the Silpasi, Your Worship, in my place, Your Worship.
Undertakes to appear for
Respond number 2 and 4, my lord.
response number 2 and 4.
2 and 3.
4. Always principal.
No, Sindhu. Sindhu ಬಂತು ಇವರು.
You know, last time this court has directed the government to whether the annexure C relieve implemented or not. No, they are relieved, already they are relieved me, Lord. Annexure D, they join the Silpasi, principal has
My lord, I'll
rejoined.
produce the order sheet, my lord. There was no interim order as on that date. And even the case has been disposed of. There was no interim order on that date. 2 weeks time, I apply for the certified copy and produce. I got the court, High Court website or copy, my lord. I'll
My
produce
lord,
the certified copy
My
itself.
lord, case
As
is
on the
not,
date of,
My lord, case is not only that is disposed of, there is a final order not released, relieved, my lord.
That order was passed in 2009.
that was, my lord, 2019,
2009 interim order.
in 2019 in writ petition.
19.
Yes,
Aye,
on 2023, interim order was not vacated.
been taken now.
Allah, that is when the interim order was not extended, but only till next date of hearing, interim order was there. Interim order was not extended. It was not extended. On 25/10/2023, at the request of the learned counsel for the petitioner, release the matter next week. Interim order was not extended.
So you want to take advantage?
No,
of
not advantage, my lord.
Then?
It is not advantage. We are not taking the advantage.
Ah.
My lord, whenever the,
Take of the council if that
No,
submission is not made seeking extension, you want to take
no,
advantage?
I am not taking advantage. That's why I'll place all the materials on records. My lord, 2 weeks time may be granted. My lord,
ಏನ್ ಮೆಟೀರಿಯಲ್ ಪ್ಲೇಸ್ ಮಾಡ್ತೀರಾ? ಇದೆ.
Allah, idalla,
That it was not extended, so we have
whether relieved or not, I'll just seek information. Na interim order idu ಹೇಳ್ತಾ ಇಲ್ಲ. Just I'm saying, my lord, for I have not yet received the papers also.
please instruct your office.
I'll instruct, my
They
lord.
will not be permitted to take
Yes,
advantage of these.
I'll inform, my lord.
ಅದೆಲ್ಲ ಆಗೋದಿಲ್ಲ.
I'll inform.
We are not going to tolerate that.
I'll inform, my lord. Regarding that, I'll inform because I have not yet received the papers also. Yesterday evening, police has informed them to that the matter is.
Then how are you saying that he has been relieved?
My lord,
How are you saying he has been relieved?
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ relieved ಅಂತ ಹೇಳಿ. ನಾವ್ ಹೇಳಿಲ್ಲ, ಅವ್ರು relieved ಅಂತ ಹೇಳ್ತಾರೆ.
Kindly
ನಾನು
annexure, annexure, kindly see the annexure D. Annexure D.
I am only saying regarding yesterday I took out the printout of the writ petition. It's showing disposed of.
My lord, on the basis of annexure D, kindly see.
2019 ಅದು.
38/2019, my lord.
It have been 19.
19 ಇದೆ.
My lord, kindly see annexure D, my lord, page number 20, my lord, where the principal has acted, my lord, purposely acted, my lord, principal.
Next para. Learned counsel, Shri Kripasagar Patil is once again directed to secure instructions as to whether the order at annexure C dated 23/9/2024 has been implemented and whether the complainant has been relieved from the post of assistant cum computer operator at Srimati Indira Gandhi Residential School, Mudubi, Basava Kalyan Taluk. Full stop. Release this matter
On 12th,
on 5th of December.
12th, because 11th and brother marriage is the 12th.
You know,
12th, brother marriage is 11th. After that, 12th,
we will have it on third itself.
cards ಅದು ಕೊಡಕ್
This is
ಹೋಗಲ್ಲ.
only to
Yes,
say whether he has been relieved or not.
Yes, then it
Rest
may
of
be,
it we will,
it may be taken
take
up on
further
7th or 8th, my lord.
huh?
7th or 8th.
Now, 5th is correct, Ashok.
Saturday, Sunday.
Sorry, my lord, I am seeing on 5th or 6th, my lord.
5th, Ashok.
5th of December.
Please, my lord. My lord, there will be direction to serve the copies, my lord. We have not received the contempt copies. Only police intimation has.
For the complainant is directed to serve copies of the petition
Please.
along with annexures on learned counsel for response number
2 and 4, my lord.
2 and,
Please.
yes.
Hearing on
Blaga.
seal number 7, Adlur Satyanarayana Acharya.
Petitioner has filed two appeals, one regarding dismissal of the diverse petition, another regarding the counterclaim that was.
Lord,
filed
I
by
am
the-
appearing for a respondent in this case.
The delay of 132 days in filing both the appeals. You are suffering from habeas hepatitis. That is B, 132 days delay in filing the both the appeals.
Petition was filed by you
Yes, ma'am.
seeking
I am
dismissal.
not audible, my lord.
The petition has been dismissed.
Dismissed. The counterclaim for restitution of conjugal rights has been granted to her.
Huh?
Restitution of conjugal rights has been granted to her. There's a counterclaim. So in respect of that also I have filed the appeal. Both appeals are. Matter may kindly be referred to.
Connected matter,
mediation.
huh?
Yes, ma'am.
With permission of your lordship, I am not audible.
What do you say about delay? Condonation, application for condonation or delay? There is a delay of 132 days in filing the appeal. What do you say? ಏನ್ರಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅಂತಾರೆ. You're not able
I am
to
not
hear.
audible, my lord. I will, it may kindly pass over, my lord. I will file objections.
Huh?
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
At the request of learned counsel for the respondents, release this matter on 5th of December.
In the meantime, it may kindly be referred to mediation. There, the fag end of retirement, my lord, is very
ಅವ್ರು
much.
ಬರ್ಲಿ ಇರ್ರಿ.
ಬರ್ಲಿ.
Next time, you please come to the court. Every time you are making.
I request
submissions
your
to video
lordship to
conference.
pass over the
And
matter.
this is the problem.
I am not audible, my lord.
That is your problem, sir. It is not our problem. Release this matter on 5th of December.
Yes.
To enable the learned counsel for the respondent to make submissions on IA number 1 of 2023 in both the matters. Yes. Huh? Notice. Learned counsel Shri Sindol.
Second, same.
ಏನ್ ಹೆಸರು ಅವ್ರದ್ದು?
Hanmantra Sindhu.
Hanumantraya Sindol is requested to take notice for the respondent in the connected matter.
Connected.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on learned counsel for the respondent. Appeal memo along with annexures and copy of IA.
Yes.
Yes.
CL number 8, Mahantesh Patil.
This is, yesterday your lordships have heard this matter. Section 7B of the Family Courts Act.
Huh?
Section 7B of the
Yesterday's
Family
matter.
Courts. How this?
Yes.
Hello.
Huh?
They limited this thing, you have to be only touch upon that issue. Let other issues not be touched upon.
Allala, you don't want to get clarification from the
No,
Supreme
I
Court?
got it. I got the clarification.
Ah.
In fact, that was never our defense in the written statement. The court so moto had raised that issue.
ಗೊತ್ತಾಯ್ತು.
ಆಯ್ತು. ಅದಕ್ಕೆ
right.
it was not at all our defense. Our case was that yes, family court has jurisdiction.
ಹಾ
So ಅಷ್ಟೇ ಬರಿಬೇಕು ಮತ್ತೆ.
ಆಯ್ತಾ, we can allow them.
We can
There is no need to send for clarification.
no clarity.
ಬೇಕಾಗಿಲ್ಲ. All right.
Not, since there are
ಅಲ್ಲ,
two judgments.
That the suit is maintainable before the family court. ಅಷ್ಟೇ.
Family court has jurisdiction.
ಅಷ್ಟೇ.
Suit ಅಷ್ಟೇ ಮಟ್ಟಿಗೆ.
Nothing more.
ಯಾಕಂದ್ರೆ
All other contentions will be kept.
yes, because something else is touched upon then it will be called.
All right.
Not since there are two judgments, my lords, which are similar strength, are not rendered different
ಆಯ್ತು,
expression.
ಏನ್ ಒಪ್ಕೋತಾ ಇದಾರೆ.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಸಮಸ್ಯೆ ಇಲ್ಲ.
ಹಾ.
Just I am bringing to your lordships another judgment. One, the three judges bench ಇದೆ. Therefore,
Clarifying this position.
ಹೌದು, section 7C has been considered. my lords. So
One
that's-
B and C, both in both cases, the family court has jurisdiction.
ಅದೇ
ಪ್ಯಾರಾ 10 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಪ್ಯಾರಾ ಎಲ್ಲ ಓದಂದ್ರೆ ಓದ್ಬಿಡ್ತೀನಿ ಒಂದ್ಸಲ.
2003.
ಹೌದು.
This is a
Three judges
much earlier.
earlier so. And it is three judges bench.
And both those judgments have not noticed this one.
ಅದಕ್ಕೆ ಇದು ಹೆಲ್ಪ್ ಆಗುತ್ತೆ.
Yes.
My lords, may read our entire, my lords, just relevant time.
Relevant ಓದಿದ್ರೆ ಸಾಕು.
Para 10.
ಪ್ಯಾರಾ 10 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಇಲ್ಲಿ ಹೆಡ್ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಸಿ ಅಲ್ಲಿ
ಹಾ ಸರ್.
ಅದನ್ನ ಓದಿ ಆ ಕೆಳಗಡೆ
ಪ್ಯಾರಾ 10.
ಅಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್.
The appellant married the respondent on 3/1/1988 and divorced her on 1/11/1995. The respondent filed a suit in the family court alleging that the appellant had purchased the specified properties out of the amount given to her in cash or by way of gold ornaments. At the time of marriage, that prior to the date of divorce, an agreement was executed between them to the effect that the property so purchased would be transferred in the name of respondent by the appellant. The suit was decreed in favor of the respondent by the family court, and the decision was affirmed by the High Court. The appellant filed the instant appeal by special leave. The appellant contended that the words "a suit or proceeding between the parties to a marriage" should be treated as referring to the parties to a subsisting marriage. The appellant further contended that since in an application filed by the respondent under section 3 of the Muslim Women's Protection of Rights on Divorce Act 1986, an amount of rupees 1,33,200 was awarded in our favor, the impugned proceedings were not maintainable. Then
ಅಲ್ಲೇ ಓದಿ ಕೆಳಗಡೆ ಹೇಳಿ.
The Family Court Act was enacted to provide for the establishment of family courts with a view to promote conciliation in and secure speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith by adopting an approach radically different from that adopted in ordinary civil proceedings. The SAD Act was enacted despite the fact that the Order 32A CPC was inserted by the Amendment Act 1976, which could not bring about any desired result. The wordings dispute relating to marriage and family affairs and for matters connected therewith must be given a broad construction. The statement of objects and reasons clearly shows that the jurisdiction of the family court extends inter alia in relation to properties of spouses or of either of whom, which would clearly mean that the properties claimed by the parties thereto as a spouse of the other, irrespective of the claim, whether the property is claimed during the subsistence of marriage or otherwise. To read the words "a suit or proceeding between the parties to a marriage" to mean parties to a subsisting marriage, that would lead to miscarriage of justice. It is well settled that the jurisdiction of a court created specially for resolution of disputes of certain kinds should be construed liberally. The restricted meaning of "if" ascribed to section 7 explanation C of the act would frustrate the object whereof the family court were set up. And the relevant would be one of para 17, the para 17 ali that has been referred.
Yes.
Para 11 and 17 is the as indicated herein before. Balkrishna Justice, as his lordship then was speaking for a division bench in a matter arising out of a preliminary issue on the question of jurisdiction, held that the dispute over properties between the parties to a marriage cannot be confined to the parties to a subsisting marriage. We agree with this sad view. The sad decision being in inter parties and having attained finality would operate as res judicata. 14 and 10, 14.
C refers to a suit
Or
or proceeding between the parties to a marriage with respect to the property of the parties or of either of them.
see, yesterday also we read.
This cannot be given a restricted
ಹೌದು.
meaning.
Para 8 ಅಲ್ಲಿ your lordships may see in the judgment.
Anyway, we will leave all that questions open. If they raise such a contention, and if it is found that you have to seek a prayer regarding
Properties.
you can do so. Or if you don't do, then they will get a cause of action again to come before this court.
Only with respect to showing that, my lords, it's 7B, the courts have interpreted that there was a contention was raised.
Adike he is accepting it. That is, there is no difficulty. But since you have not made prayer
There is no prayer with regards to
seeking
properties.
declaration in respect of the property, that you should be declared the owner of the property. And if such a prayer is not made,
What would
normally in a civil suit,
The suit stands.
such an objection can be raised, and therefore you should be permitted to raise that objection, is what he is saying.
I am permitted also. I have already raised my
You
objection.
have raised.
It's not an issue now. It's only whether this family court has jurisdiction to entertain such a suit or not.
So,
And it has.
so
Yes,
issue has been framed
issue has also been framed.
in respect of property.
Properties.
ಆಗಿದೆಯಾ? ಸರಿ ಮಗ.
ಆಗಿದೆ.
Agide. That is why I went through the issue. I found out that everything what I had argued for is already covered there.
Delay of 84 days in filing the appeal is condoned. Next para. The appellants who are the legal representatives of Srimati Narsamma, who had filed OS number 28 of 2022 before the Principal Judge Family Court at Raichur, are before this court aggrieved of the impugned order dated 25th of July 2023, passed by the family court, returning the plaint to the plaintiff on the ground that the suit filed before the family court is not maintainable in law. Full stop. Next para. A brief background is required to be stated as to how such a suit came to be filed before the family court. Full stop. Srimati Narsamma appears to have approached the revenue authorities seeking mutation and entry of her name in respect of landed properties which were earlier standing in the name of her husband, late Shri G. Narsanna. Full stop. Supreme Court order
That's at page number. ಅದರಲ್ಲಿ
Right ಆಗುಂಟು. ನಿನ್ನೆ
Yeah,
ಕೊಟ್ಟಿದ್ದು.
ಇದ್ರಲ್ಲಿ. ನೆನ್ನೆ ಕೊಟ್ರಲ್ಲ ನೀವು?
ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದು.
ಹಾ, ಇಲ್ಲಿದೆ.
page number 12 of the order itself.
The revenue authorities entertained the claim of Srimati Narsamma and set aside the mutation dated 5/2/2001, which was made in favor of the respondents here. Full stop. Feeling aggrieved, Srimati Narsamma, the respondents challenged the order of the revenue authorities before the deputy commissioner. Full stop. The deputy commissioner allowed the appeal and
Revision. Allowed the
revision and set aside the order passed by the revenue authorities, thereby ensuring that the revenue entry made in favor of the respondents continue. Full stop. The matter came up before this court, and thereafter the respondents took up the matter before the Honorable Supreme Court. Full stop. The Honorable Supreme Court, by order dated 21st of November 2022 in Civil Appeal number 8654 of 2022, arising out of SLP bracket C number 18779 of 2022, held that the recourse adopted by Srimati Narsamma in approaching the revenue authorities is an exercise in futility, as neither the deputy commissioner nor any other revenue authority is competent to determine the status of the parties as to the legal status. Full stop. Such a controversy the Honorable Supreme Court held that such controversy can be decided by civil court only. Full stop. Srimati Narsamma submitted before the Honorable Supreme Court that she will file a civil suit seeking declaration of her marital status. Full stop. Accordingly, the matter was disposed of while directing that till the disposal of the civil suit, the respondents shall neither alienate nor create any encumbrance upon the suit property. Full stop. Thereafter, the suit in OS number 28 of 2022 was filed by Srimati Narsamma before the Principal Judge Family Court at Raichur. Full stop. Preliminary issue. Issues were framed, and issue number 5 was taken up as preliminary issue, which is, open note commas, whether this suit is maintainable under law in this family court, question mark, close note comma. Full stop. Next para. The learned Principal Judge, family court while considering the arguments made on behalf of the plaintiff and the defendants, and on consideration of a judgment of the Honorable Supreme Court in R. Kasturi and others versus M. Kasturi and others, reported in 2018 bracketly 5 SCC 353, held that principally the dispute is amongst the plaintiff and defendant, who claim to be the legally wedded wife of Sri Narasanna, late Sri Narasanna, to whom survey numbers 184/A, bracketly old survey number 184, close, extent measuring 8 acres 24 guntas, situated at Raichur, and therefore dispute involved in the suit is not so simple as submitted by the learned counsel for the plaintiff to claim relief of declaration of plaintiff, declaration that the plaintiff is the legally wedded wife of late Sri Narasanna, without claiming necessary and consequential reliefs in respect of the landed property involved between the parties. Full stop. It was held that such dispute involved in the suit cannot be decided by a family court by adopting summary procedure as contemplated in the Family Courts Act, 1984. Full stop. Accordingly, the plaint was ordered to be returned to the plaintiff to enable the plaintiff to present the same before a civil court having competent jurisdiction. Full stop. Next para. Learned counsel for the appellants. Next para. So Srimati Narasamma died after this order was passed. Huh? You have filed the appeal along with the application to seek leave to file the appeal. Huh? After the order was passed by the family court, Srimati Narasamma died, and therefore her legal heirs have filed this appeal along with an application seeking leave of the court to permit them to prosecute the appeal. Full stop. Next para. Having regard to the facts narrated herein above, this court is of the considered opinion that the application filed by the appellants seeking leave of this court to prosecute the appeal is required to be allowed and is accordingly allowed. Full stop. Next para. Learned counsel for the appellants. Placed reliance on two judgments of the Honorable Supreme Court. Full stop. It was submitted that a three-judge bench of the Honorable Supreme Court in the case of K.A. Abdul Jalil versus T.A. Shahida, bracket 2003, close 4 SCC 166, while considering the scope and jurisdiction conferred on the family courts under the Family Courts Act 1984. Held that the Family Courts Act was enacted to provide for the establishment of family courts with a view to promote conciliation in and secure speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith by adopting an approach radically different from that adopted in ordinary civil proceedings. Full stop. The said act was enacted despite the fact that Order 32 capital A CPC was inserted by Amendment Act of 1976, which could not bring about any desired result. Full stop. It was therefore held that the words inert commercially disputes relating to marriage and family affairs and for matters connected therewith, close inert comma, must be given a broad construction. Full stop. It was held that the statement of objects and reasons clearly shows that the jurisdiction of the family court extends, inter-alia, in relation to properties of spouses or of either of them, which would clearly mean that the properties claimed by the parties thereto as a spouse of the other, semicolon, irrespective of the claim, whether the property is claimed during the subsistence of marriage or otherwise. Full stop. It was held that to read the words, inert commercially, a suit or proceeding between the parties to a marriage, close inert comma, to mean, again open inert comma, parties to a subsisting marriage, close inert comma, would lead to miscarriage of justice. Full stop. Further, it was held that it is well settled that the jurisdiction of a court created specially for resolution of disputes of certain kinds should be construed liberally. Full stop. The restricted meaning, if ascribed to section 7, explanation bracket C of the act, it would frustrate the object wherefore the family courts were set up. Full stop. It was also pointed out that in the case of Balram Yadav versus Falmania Yadav, comma, bracket ಅಲ್ಲಿ 2016, close bracket 13 SCC 308, comma, a 2 judges bench of the Honorable Supreme Court, comma, while considering Section 7 of the Family Courts Act, seven and 8 of the Family Courts Act held that under Section 7 bracket 1, explanation bracket B, comma, a suit or a proceeding for a declaration as to the validity of both marriage and matrimonial status of a person is within the exclusive jurisdiction of the family court, comma, since under Section 8, comma, all those jurisdictions covered under Section 7 are excluded from the purview of the jurisdiction of civil courts. Full stop. It was further held that in case, comma, there is a dispute on the matrimonial status of any person, comma, a declaration in that regard has to be sought only before the family court. Full stop. It makes no difference as to whether it is an affirmative relief or a negative relief. Full stop. This observation was made by the Honorable Supreme Court since the plaintiff had sought for a declaration before the family court that the respondent was not the legally married wife full stop. It was further held that what is important is the declaration regarding matrimonial status. Full stop. It was also held that Section 20 also endorses the view which the Honorable Supreme Court has taken, comma, since the Family Courts Act, comma, 1984, comma, has an overriding effect on other laws. Full stop. Next para. Although learned counsel for the respondent faintly sought to support the impugned order, which was mainly based on another decision of two judges bench in the case of Kasturi bracket Supra,
R Kasturi.
comma, the learned counsel accepted the fact that in the said judgment, the provisions of the Family Courts Act were not considered. Stop. However, learned counsel for the respondent submits that where are the issues framed? ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಿ.
Page number 44.
Huh?
Page number 44.
44.
Issue number 6.
44.
Huh. 43, 44.
41.
41 in start ಆಗುತ್ತೆ. Fresh issues and ಮತ್ತೆ again reframed. ಅಲ್ಲಿ issue number 6.
ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಯಾವ್ದು ನಮ್ಗೆ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ.
I will
43 ಇದೆ ನೋಡಿ. ಫೈಲ್ ಕೊಡಿ minute.
Copy of issues ಆಗ್ತದೆ.
Issue number 6.
So you have not raised any objection to this.
No, they are not raised.
The issue is framed regarding.
Frame ಆಗಿದೆ.
ಹೌದು.
As they had sought, issues have been
Issue
framed.
has been framed.
So the court can go ahead.
Court can go.
Huh? All.
Even we can seek for even amendment also now by virtue. The one
issues frame ಆಗೋಗಿದೆ.
ಆಗಿದೆ.
In respect of, there is only one property.
ಹೌದು.
ಅದ್ರ ಬಗ್ಗೆ issues frame ಆಗಿದೆ
ಆಗಿದೆ.
Then if you have admitted and you are not raising any objection to the framing of the issue, the court will go ahead. ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ನಾವು ಮಾಡಬಹುದು.
Huh?
Now amendment we can seek it not
ಆಯ್ತು.
to add
Formally-
another prayer. Consequential prayer we
Let
can
us not, let us not debate on that, my lord.
ಅಲ್ಲದ
You will formally observe
ಅಷ್ಟೇ.
that in view
Please
of
leave
the
Contentions raised by me, issues are
and
already,
issues being framed,
issues are already raised. It's-
formally the plaintiff may seek amendment of the
ಅದು ಮಾಡಿದ್ರೆ ಮತ್ತೆ then they will be, because they have already sought an amendment that has been dismissed.
ಸರಿ ಆಯ್ತು ಬೇಡ.
ಬೇಡ, ಅದಕ್ಕೆ ಬೇಡ ಅಂತ ಮತ್ತೆ will create complications.
amendment ಯಾವುದು ಕೇಳಿದ್ರು
Submits.
ಎಲ್ಲಿ
That the prayer in the plaint is seeking a declaration that the plaintiff is the wife of deceased Sri G. Narsanna, son of Hanumantappa, and no prayer was made insofar as the landed property belonging to Sri Narsanna. Full stop. Nevertheless, the further proceedings in the suit and the family court framing fresh issues even in respect of the landed property would satisfy the requirement of the defendants to go into the question as to the title over the landed property. Full stop. Anyway, they are also not concerned. They only wanted to see that the issue is framed. The court will go into that question.
Court will go into that.
Now, let us not go into the question of court P.
Only marital status and jurisdiction of the court which is not subject matter.
ಅದಕ್ಕೆ ಅಷ್ಟರ ಸಲಕ್ಕೆ we are restricted, but other issues are already covered by the court.
ಈಗಾಗಲೇ issues frame
ಅದೇ
ಆಗಿದೆ.
ಅದಕ್ಕೆ.
That apprehension that I had
Number
exhibited is already met by framing an issue of that kind that can be decided by the courts.
Stop. In that view of the matter, learned counsel for the respondent submits that the appeal may be allowed
ಅದು ಬೇಡ.
to enable the family court to proceed with the matter.
ಅಪೀಲ್ ಮೇ ಬಿ ಅಲೌಡ್ ಅಂತ ಬೇಡ. Normal objections.
Last sentence ತಗ್ಬಿಡಿ ಬೇಡ. All. Next para.
Since that issue framed or since the prayer in the suit meets the requirement of explanation B of section 7, the court has jurisdiction to try the suit. ಅಷ್ಟೇ.
ಏನ್ ಪುತ್ತಲ್ಲಿ? As provided in clause C of the explanation to section 7 of the Family Courts Act, 1984. Full stop. Next para. In view of the above, having regard to the judgments, the judgment of 3 judges in the case of Shri K.A. Shrila K.A. Abdul Jalil bracket Supra and the decision in the case of Balram Yadav bracket Supra, which has considered the scope and jurisdiction of the family courts having regard to the provisions contained in the Family Courts Act, this court is of the considered opinion that the impugned order cannot be sustained. Full stop. Next para. Consequently, the appeal is allowed. Full stop. The impugned order dated 25th of July 2023, passed in verse number 28 of 2022, is hereby quashed and set aside. Full stop. The original suit in verse number 28 of 2022 is restored to the file of the Principal Judge, Family Court at Raichur. Full stop. The learned Principal Judge, Family Court shall proceed from the stage when which the suit was returned, the plaint was returned to the plaintiff, consider the matter and dispose of the same as expeditiously as possible and at any rate within a period of 6 months, 6 months from the date of receipt of a certified copy of this order. Ordered accordingly.
Any observations made shall not be.
Huh?
Observations any made.
ಏನು
There
ಮಾಡಿಲ್ವಲ್ಲ?
is no observation on the merits.
I also heard it, Madila, but still there will be always scope in the trial court
ಹಾ.
for interpreting and reinterpreting the orders of the court meaning and the kirikiri bad ಅಂತ.
Only jurisdiction point your lordships
Any
have addressed.
observations made?
Not about any merits ಬಗ್ಗೆ ಏನು ಹೇಳೇ ಇಲ್ಲ.
ಹ್ಮ್.
One submission in R Kasturi case, there were provisions 13, 14 and 15 of the act were considered, but not the section 7B. ಅದು ಯಾವ್ದು provision consider ಆಗಿಲ್ಲ ಅಂತ ಬಂತೇನು?
ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ, ಅದು ಮತ್ತೆ
ಸರಿ. All. ಅಲ್ಲಿ ಕಸ್ತೂರಿ ಸೆಕ್ಷನ್
13, 14 and 15.
13, 14, 15 ಅಂತ ಹಾಕೊಂಡ್ರಿ. ಆ ನಾನು ಅದನ್ನ ಅಲ್ಲಿ ಎಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀನಿ. ಎಸ್.
Seal number 9, Vishal Pratap Singh.
Sir, my lords, as far as juvenility is concerned,
ಹಾ
appellant's juvenility,
ಹಾ ಹಾ.
that one person who has issued the birth certificate, I mean the school certificate.
ಹಾ ಹಾ.
Yes,
ತೆಲಂಗಾಣ.
yes, my lords.
ಹಾ.
The inspector is present, my lords. He requested him, he sought for 1 week time. So within 1 week, they'll come.
Learned additional SPP submits that ಇವ್ರು ಯಾರು?
He's RG Nagar,
ಹಾ
RG Nagar inspector.
ಯಾವುದು?
Raghavendra Nagar police station inspector he is, where the case has been raised.
ಇಲ್ಲಿ.
ಹೌದು.
That the jurisdictional police.
CPI.
Huh?
CPI.
The jurisdictional
Circle inspector.
circle inspector of police is present before the court.
Yes.
And on instructions, it is submitted that the competent authority of Telangana.
Yes.
Who is required to issue the information regarding the school records.
Yes.
Of
Appellant.
the appellant,
Yes.
appellant, of the appellant, comma, has sought for a week's time.
Week's time, my lords, my submission would be 2 weeks' time may be granted, my lords,
I-
because within that, if it,
Time has been crafted.
To furnish the information.
please,
Full stop. Next para. Release
within
this
that, if
matter
it has come, you.
Release
you-
this
you
matter.
file a-
on 9th of December.
Please.
Grateful minutes.
ಬರ್ಬೋದು. ಯಾವ್ದು?
Preliminary matters,
ಈಗ ಮಾಡಿ.
seal number 10, Mahantesh Patil.
I am grateful to you, Lord.
Lord, this case, my lord, there is a writ appeal also, my lord. The order, my lord, challenging.
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
House. Lord, our grievance is only, my lord, restricted this thing.
Escom.
Just come, my lord. Lord, after injury, my lord, in fact, the
ಈ ಕಂಟೆಂಪ್ಟ್ ಕೇಸಲ್ಲಿ learned counsel Shri Sudarshan M.
Please.
Takes notice for the respondents.
Published.
Learned counsel for the complainant is directed to serve copy of the petition along with annexures from the learned counsel for the respondents.
Please.
ಹೇಳಿ.
Please.
ಐದು
Lord,
ಕೊಡ್ರಿ.
in this
Appeal
petition,
ಕೊಡಿ. ಹಾ.
Lord, the writ appeal, Lord, against him, Lord, order of the learned single judge, wherein, Lord, the compensation is awarded. Lord, looking into them, Lord, the victim, Lord, came
Is
in.
caused
Please,
and disability suffered by the petitioner
please,
due to electrocution.
electrocution, high tension wire, my lord, which he came in contact and, my lord, sustained, my lord, amputation. That is, my lord, 10-year-old boy. And, my lord, we, in fact, my lord, the houses which were, my lord, below the, my lord, high tension wire, Lord, the JESCOM has, my lord, already given a notice and, my lord, requested them to vacate. And but my lord, due to my lord, unfortunately, my lord, this is an incident took place, my lord, because of my lord vacating, and that is one part, my lord. And my lord, even if my lord, this my lord,
Villagers were
compensation.
requested.
Shift.
The villagers requested the respondent authority to shift. ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು, you requested them to
We requested them
move out of that place.
move out of the place.
By remove.
ಹಾ.
My lord, that is my lord at page number 62. My lord, annexure G1, wherein my lord, reply notice cast to the my lord, legal notice issued by the counsel of the my lord victim, wherein it is
Any
been,
photograph produced?
yes, my lord, it is there. 61, 62 onwards, my lord. Page number 62 is a reply notice, and thereafter photos.
ಅವ್ರದಲ್ರಿ, ಆ ಹುಡುಗಂದಲ್ರಿ,
Yes.
photograph of the place.
And that is not, my lord, produced at this moment.
In fact, not in the year 2011 itself, they have given all the villagers, my lords, made a representation to shift since it was endangering to the life, my lords. In spite of that, they did not shift.
What is the type of construction that you had put up?
Earlier only not there were houses. There were 60 houses which were not the 60 residents were given the representation in the year 2011 itself. Then they themselves have visited the spot and they told that, my lords, they returned there was internal official communication that stating that it has to be done in the self not financial scheme. Thereafter they they not took any further steps to take any action, my lords. Because of that reason, it has resulted in the.
What are the grounds?
Please, my lord, that is one ground, my lord, and the
ಏನು?
second ground is, my lord, regarding.
What have you stated?
My lord, my lord contention before my lord learned single judge was, but that is how we given my lord notice to the my lord residents who were my lord put up their construction below the my lord high tension wire to vacate immediately. And my lord, even then my lord, this my lord boy went to the my lord one of the my lord residents' house, and while catching the my lord pigeon, he my lord caught my lord.
ಅದಕ್ಕೆ ರೀ, I
ಅದೇ.
read that statement.
ಹೌದು.
That is why I want to see.
Please.
What is the type of construction they had put up? Whether that construction was permissible to be put up? What are the grounds that you have taken?
My lord, here my lord, my main ground is my lord. Lord, we are not given with an opportunity to, Lord, examine or cross-examine, Lord, as because, my Lord, 2013, the matter was, my Lord, in 15, my Lord, he approached the, my Lord, the consumer forum, and consumer forum, my Lord, he approached the victim, and my Lord, there, my Lord, matter was, my Lord, dismissed as withdrawn. As my Lord, he wanted to further, my Lord, file it to the, my Lord, state commissioner somewhere, my Lord. And thereafter, my lord, he kept silent, my lord, for so many years, my lord. Then, Lord, writ
Then
petition
directly a writ petition is filed.
directly writ
Writ petition is filed.
Writ petition is filed.
Huh.
And then, my
What is
lord,
your legal contention now?
legal contention is, my lord, one is, my lord, the liability aspect itself, my lord, we are denying. As, my lord, my lord, whatever the incident took place because of their negligence and not vacating the, my lord, or clearing the, my lord, house from the, my lord, place.
Above matter cannot be adjudicated by this court, and the petitioner being required to be relegated to the civil court. So you have taken up that contention.
Yes. And my lord, as because, my lord, both the parties should be given with, my lord, opportunity to adduce evidence. And here, my lord, straight away, my lord, looking into the FIR and, my lord, notice issued. Lord, the honorable court has come to the conclusion by fixing, Lord, 25 lakhs and odd. And that is how, Lord, our, otherwise it will be a, Lord, binding precedent for others. Lord, coming in, Lord, before directly in writ petition.
Yes, what do you say?
Lords, in fact,
all this requires evidence.
Lords, in fact, the learned single judge.
Very moment I read this word, that he tried to catch the pigeon and he came in contact. So we want to know what is the type of construction that was put up, whether that construction was permissible, And whether it
Till
was in
one
accordance
submission.
with law, if the lines were put earlier
Then houses
and
were
thereafter you
constructed.
have gone and built the house,
That
then
I
it
know,
is your.
that is the, after,
mistake.
after the houses when they may lots.
Adike,
Adu-
where is the evidence for all this?
They have done lots inspection, they have to have been produced. When we made a representation.
Normally, a writ petition of this nature cannot be entertained.
My lords, that is why the learned single judge has relied on the judgment reported, my lords, in the Reka and other sources, Karnataka Power Transmission Corporation Limited and others. Para 24 ಅಲ್ಲಿ.
Kodi, judgment idra kodi.
ಅದು ನನ್ನ ಹತ್ರ ಇಲ್ಲ. That is that I will furnish that copy.
Then for the time being, we'll stay this operation of this order.
Lords, my request one thing, lords, it may be urgent to next week so that I will get the judgment also. There were other judgments also, my lords, which even the division
us see,
bench and
let us Otherwise, you'll now insist.
now
on,
lords, I will not insist
execution
for
of
the.
the.
Allah, I will
order,
not press for the contempt since the writ appeal is filed. I know that not the issue requires consideration.
Mm.
I request that not it may be urgent. I will not press for the contempt. Let there be not adjournment for in simplicity, so that I will get the judgments and make submissions. Because what happened is, my lords, the why the judgment is rendered is, in spite of giving representation, then thereafter conducting the inquiry by the authorities, they have, my lords, visited the spot. Then they themselves have written that there was the wire is not below the average line, because the rules are maintained by them only. It prescribes not minimum height. Therefore, all those things were happened. Then also they did not take any action. It's not about not going and not in a.
They have taken a stand that such a writ petition cannot be maintained. You will have to approach a civil court,
But that
lead evidence, give an opportunity to the other side also to have their say.
That-
Without recording the evidence, it is not permissible. That is the stand that they have taken.
that is the stand was taken, my lords. In the Reka judgment, which I am not shown, reported judgment, my lords. In that judgment, there were several contentions were raised these type of notes. And earlier also there were several judgments and several high courts have held that some of the cases they have allowed, some of the cases they were dismissed based on the certain facts.
Correct.
And
It
this
all
court,
depends on the fact.
this court, my lords, has
If there is no scope
ಹೌದು.
for any contention from the side of the
ಹೌದು.
electric department,
based on admitted
then
facts.
courts can go.
ಅದಕ್ಕೆ that is why I will get the judgment and I will get the another 3-4 judgments are there not. I will produce those judgments. I will not press for that contempt because I know that it has to be heard. The issue it not.
ಎರಡು ಒಂದೇ. I will have to record your undertaking.
Undertaking ನಿಮ್ದು ಯಾಕ್ ಕೊಡ್ತೀರಾ?
ಆಯ್ತು. Stay.
ಅಲ್ವಾ? Having regard to the grounds raised in the appeal, that disputed questions of fact cannot be gone into by this court under writ jurisdiction. And the claim of the respondents or writ petitioners will have to be substantiated by recording evidence and that the respondents, that the appellants will also have an opportunity to place evidence and material to show that there was no negligence on their part, we are of the opinion that the matter requires consideration. Full stop. Next para. Consequently, there shall be stay of the impugned order passed by the learned single judge in WP number 202965 of 2015, dated 21st of June 2023. During the pendency of this appeal. Yes.
Please, Machu.
Delay of, next para, delay of 142 days in filing the appeal is condoned.
Please, Machu.
Yes.
Seal number 13, Mahantesh Patil. Seal number 13.
Matter is called out. There is no representation for the respondent. Release this matter on 5th of December.
Seal number 14, SS Haspalli.
Matter is called out. There
Appearing
is
for
no
the respondent.
representation for the appellant. Release this matter on 5th of December.
Seal number 15, Sharada Patil Kulgeri.
Same order, no representation for respondent. Yes.
Seal number 16, Baburao Mangani, Ashok Mulage.
My lord,
Suspension of sentence.
morning additional SP.
Only
he
7
request
years.
to adjourn
At the request of learned additional SPP,
and next week, my lord.
release this
Already,
matter on 5th.
already matter is heard.
Huh?
The matter is heard 3 times.
ಹಾ,
But they have.
ಅದೇನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಬೆಳಿಗ್ಗೆ,
ಅದೇ ಅವ್ರ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿ
ಯಾವ್ದಕ್ಕೆ,
Monday
ಏನಕ್ಕೆ?
Monday ಅಂತ.
ಹಾ?
They sought for time Monday ಅಂತ ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ ಅಂತ ನನಗೆ ಹೇಳಿದ್ರು.
ಹಾ, Monday
Monday.
on 2nd of December.
Yes.
Please.
All right.
B group matter, seal number 17,
My
Ravi
lord.
B Patil.
17 matter, I have prepared calculation sheet, my lord, it will produce. It will filing in counter, my lord, it will be taken next week.
Matter is called out. There is no representation for the petitioner. Release this matter on 5th of December.
Yes, my.
Seal number 18, Mahesh Patil. 18.
Same order.
Seal number 19, for final disposal, MIL Kulkarni.
No representation for either of the parties. Same order.
Seal number 20, further hearing. Allah Baksha M.
File the undertaking affidavit, my lord, in that divorce matter.
Huh?
Undertaking,
hearing.
please, my lord. On the other day, I filed my undertaking affidavit of the appellant husband, my lord.
We are directed you to file
Please,
the
ma'am.
undertaking.
For the,
Since they have separate from last 14 years and
Ah,
that
yes,
is on that ground.
Yes, yes.
Without there being any allegation and also desertion. They have not complied the any conditions of the, that is the reason I have also instructed the party to be present before the court.
Ah,
Whatever the, I have tried my level best
ah,
as far as the, what the court has expressed on the last date. But as far as sees,
as per my
Kindly.
undertaking affidavit, my lord, I have agreed for the wife 20 lakh rupees, for the son 10 lakh rupees in payment, my lord. Apart from the 10 lakh rupees to the
Easy.
child, my lord, 7 lakh rupees I have agreed for the child, for the education, for the 10 lakh rupees is separately, and also additionally, my lord, every year I have instructed the client, every year March 31st ಗೆ ಮಕ್ಕಳದು ಎಜುಕೇಶನ್ ಅಡ್ಮಿಷನ್ ಗೆ ಏನಾದ್ರು ಬರ್ತದೆ ಅದಕ್ಕೆ ಸಪರೇಟ್ ಇನ್ನ ಒಂದು 1 ಲಕ್ಷ ಬಂದು 7 ವರ್ಷ ಗಂಟ ಕೊಡ್ತಾ ಇರ್ಬೇಕು. ಟುಡೇ he is 14 years. I have instructed the client to deposit till 21 years. Apart from that, another 60,000 rupees every year, my lord, he has to deposit only for the, as if it is a pocket money to the child separately, my lord, apart from the 10 lakh rupees. And whenever for the admission girli, ಮಗುದು ಪೇರೆಂಟ್ಸ್ ಟೀಚರ್ಸ್ ಮೀಟಿಂಗ್ ಇರ್ಲಿ ಅಂತ ಟೈಮ್ಗೂ ಜಿಮ್ಮೆದಾರಿ ಐ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ ಮಾಡಿ.
ಏನಮ್ಮ ಬನ್ನಿ ಇಲ್ಲಿ. ಅದು ಓದಿದಿರಾ ಅವ್ರ ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿರೋದು?
ಕೊಟ್ಟಿಲ್ಲ.
ಹಾ, ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಯು ಆರ್ ಗಿವಿಂಗ್ ಟುಡೇ.
ಲಾಸ್ಟ್ Earlier, from both the side jointly ಅಂತ ಇತ್ತು,
ಹಾ.
ಈಗ single ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅದನ್ನ ನೋಡಿ ಒಂದ್ಸರಿ. ಅವರು ಏನೋ ಒಂದು ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ, ನೋಡಿ ಅದನ್ನ. ನಿಮಗೆ ಸಮಾಧಾನ ಆದ್ರೆ ಒಪ್ಕೊಳ್ಳಿ, ಇಲ್ದೇ ಇದ್ರೆ ನಾವು ವಿ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ದಿ ಮೆರಿಟ್ಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್. ಒಂದು ಲಾಸ್ಟ್ ಆಪರ್ಚುನಿಟಿ ಅಷ್ಟೇ ನಿಮಗೆ. ಕೋರ್ಟ್ ಈಸ್ ನಾಟ್ ಫೋರ್ಸಿಂಗ್ ಯು. If you want to go through that and accept it, it is up to you. Otherwise, we will consider the matter on merits and will proceed.
Weeks time may be granted.
Huh?
My lord, not weeks time. my lord. Maybe
Weeks
have
time may
it,
be
Monday, my lord. Second, my lord, 2nd December, my lord. Have it on
Second,
Monday. 2nd December, my lord.
Ah.
Monday, my lord. It may be have it on Monday.
Doesn't matter. In 3 days ಅಲ್ಲಿ ಏನು ವ್ಯತ್ಯಾಸ ಆಗಲ್ಲ. We'll have it on 5th.
Please.
Learned counsel for the appellant.
ಅದು part 3rd ಅಂತ ಬಂದಿಲ್ಲ.
Huh?
Part 3rd ಅಂತ last time your lordship
ಹೌದು.
dictated.
Further hearing ಅಂತಾನೆ ಬಂತು.
Please, yeah.
Second week of December.
ಅಲ್ಲ.
Next week. She need not come to the court also. It is only for the purpose of considering the affidavit given by the appellant. She can give instructions to you.
So already yesterday itself I have gone, discussed with her and also
ಆಯ್ತು.
everything.
Formally, you can say no, she is not accepted. We will proceed to pass orders. ಅದೇ.
Before that, one more discussion, one more opportunity to discuss with you.
ಈಗ ಅದನ್ನೆಲ್ಲ ನಾವು ಇಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲಮ್ಮ.
That
ಅದನ್ನ ನಾವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ. ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ನ ಮೆರಿಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ನಾವು ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡ್ತೀವಿ. ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, ಕಾನೂನಲ್ಲಿ ಕೆಲವು ತೊಡಕುಗಳಿದಾವೆ. ನಾವು ಬೇಸ್ಡ್ ಆನ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂಡ್ ಎವಿಡೆನ್ಸ್ ದಟ್ ಇಸ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಓನ್ಲಿ ವಿ ಕ್ಯಾನ್ ಡಿಸೈಡ್ ದಿ ಕೇಸ್.
ನಾವು ಎಲ್ಲಾ ಕೋಶಿಶ್ ಮಾಡಿ
ಒಂದು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, 14 ವರ್ಷ ಸೆಪರೇಟ್ ಆಗಿದ್ದೀರಾ ನೀವು.
ಕರ್ಸಿ ಅವ್ರ ಮನೆ ಹೊರಗೆ ಹಾಕಿ ಆಮೇಲೆ ಅವಳು ಹೊರಗಿದ್ದಾಳೆ ಅಂದ್ರೆ
ಆಯ್ತು.
ಹೆಂಗಾಗುತ್ತೆ
ಆಯ್ತು,
sir?
ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಮ್ಮ. ನೀವು ಯು ಕಾಂಟ್ ಬಿ ಸೋ ಶ್ಯೂರ್ ದಟ್ ದಿ ಕೋರ್ಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಯುವರ್ ಕಂಟೆನ್ಷನ್ ಓನ್ಲಿ. ಯು ಕೆನಾಟ್ ಬಿ ಸೋ ಶ್ಯೂರ್. ಸೊ ದೇರ್ ಫಾರ್ ವಿ ಆರ್ ಆಲ್ಸೋ ಮೇಕಿಂಗ್ ಇಟ್ ವೆರಿ ಕ್ಲಿಯರ್.
Yesterday, my lord, as far as that point is
ನಾವು
concerned.
ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕಳ್ಸಿದಾಗ್ಲೂ ಇದೇ ಮಾತು ಹೇಳಿದೀನಿ ನಿಮ್ಗೆ. ಯಾಕಮ್ಮ ಯಾರೋ ಒಬ್ಬ ಇಷ್ಟ ಇಲ್ದಿರೋ ವ್ಯಕ್ತಿಗೆ ಇಲ್ಲ ನಾನು ನಿನ್ ಜೊತೆಗೆ ಬಾಳ್ತೀನಿ ಅಂತ ನೀವ್ ಯಾಕೆ ಹೇಳ್ತೀರಾ ಅಂತ. ಇವಾಗ ಏನ್ ಹೇಳ್ತೀರಮ್ಮ? 14 ವರ್ಷ ಸಪ್ರೇಟ್ ಅಲ್ಲಮ್ಮ, ನೀವು ಸೊಸೈಟಿ ಬಗ್ಗೆ ಹೇಳ್ತಿರಲ್ಲ. ಇವಾಗ ತಾನೇ ಏನ್ ಒಳ್ಳೆ ಹೆಸರಿರುತ್ತೆ ನಿಮ್ಗೆ ಸೊಸೈಟಿಯಲ್ಲಿ. ಮತ್ತೆ ನೀವು ಗಂಡನ್ ಬಿಟ್ಟು 14 ವರ್ಷ ಇದೆಯಲ್ಲ ಅಂತ ಯಾರು ಮಾತಾಡ್ಕೊಳಲ್ವ ಹೊರಗಡೆ? ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. It's up to you. We are not going to force you. We are not going to force you. We will consider. Yes.
One before, my lords,
Huh?
one
Has
day,
filed
my lords,
an affidavit
in chamber one sala iವ್ರ ಜೊತೆಗೆ
of the appellant in terms of the undertaking given by this court on the previous occasion. A copy of the same is served on the learned counsel for the respondent. Full stop. In fact, the respondent herself is present before this court. Full stop. At the we request the respondent to go through the affidavit and submissions can be made on the next date of hearing on the proposal given by the appellant in the affidavit. Full stop. This court will also proceed to pass orders on the merits of the matter on the next date of hearing. Release this matter on 5th of December.
On that day, they may also voluntarily present before the court and
Huh?
one opportunity to
ಇಲ್ಲ
in chamber ನಲ್ಲಿ
ಬೇಡ. If there is something coming from her side, ಆಯ್ತು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ, ಏನೋ ಸ್ವಲ್ಪ ಚೇಂಜಸ್ ಬೇಕು ಅಂತಂದ್ರೆ ಮಾತ್ರ we will hear you, otherwise no.
ಇಲ್ಲ ಅದರಲ್ಲಿ that ಆ ಪಾಯಿಂಟ್ ಮೇಲೂ ನಾನು ಮಾಡಿ.
And we will proceed to pass orders on merit, sir. We can't force the parties like this. That is why we are giving one more opportunity. Please go through that. If there is any slight change in our position. ಆಯ್ತು, ಏನಾದ್ರು ಸ್ವಲ್ಪ ಬೇರೆ ತರ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಏನಾದ್ರು ಇದ್ರೆ ಮಾತ್ರ we will hear the parties. Otherwise, no. We will proceed to pass orders on merits.
ಮುಂದೆ
Let
ನನ್ನ
us see.
ಲೈಫ್ ನಂದು ಹೇಗೆ ದಟ್ ಕ್ವಶನ್ ನಾನು ನಾನು ನಿನ್ನೆ ನಾನು ಆಫೀಸ್ 1.5 hour ನಾನು ಕೂತು ಟ್ರೈ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, 2 ಸೈಡ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಜೊತೆಗಿದ್ದರೆ ಹೇಗೆ, ಸಪರೇಟ್ ಆದ್ರೆ ಹೇಗೆ ಅಂತಂದಾಗ ಒಂದೇ ಕ್ವಶನ್ ನನ್ನ ಮ್ಯಾಗ ಸಿಂಗಲ್ ಬ್ಲೇಮ್ ನನ್ಗೆ 14 ವರ್ಷ ಕಡೆಗಿದ್ದು ಟ್ರೂ. ಈಗ ಆತ ಇನ್ನೊಂದು ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಒಂದೇ ಕಾರಣಕ್ಕೆ ನಾನು ಲೈಫ್ ಲಾಂಗ್ ಸಫರ್ ಆಗ್ಲೆ. ನಾನು ಏನಾದ್ರು ತಪ್ಪು ಮಾಡಿ ನಾನು ಬ್ಲೇಮ್ ಹಚ್ಚಿ ನಾನು ರೆಡಿ ಇದ್ದೆ ನಾನು ಫೇಸ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಸಿಂಗಲ್ ಏನು ಇಲ್ಲ, ಅವ್ರದ್ದು ಏನು ಇಲ್ಲ, ಸಿಲ್ಲಿ ಮ್ಯಾಟರ್ ಇದೆ ಇದ್ರಲ್ಲಿ. ಅವತ್ತ ಸಪರೇಟ್ ಇದ್ದ ಒಂದೇ ಕಾರಣಕ್ಕಾಗಿ
ಅದಕ್ಕೆ ನಾವು ಕೇಳಿದ್ದು, ಅವ್ರನ್ನು ಕರ್ಸಿ ಕೇಳಿದೀವಿ. ಅವ್ರಿಗೆ ಸುತರಾಮ್ ಇಷ್ಟ ಇಲ್ಲ ಅಂತಂದ್ರೆ
ಇಷ್ಟ ಇಲ್ಲ, ಅವನಿಗೆ ಇನ್ನೊಂದು ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಂಗೆ ಇನ್ನೊಂದು ಮದುವೆ ಮಾಡ್ಕೊಂಡು ನೀವು ಬೇಕಾದ್ರು. ನಾನು ಏನ್ ಮಾಡ್ಲಿ, ಲೈಫ್ ಲಾಂಗ್ ನಾನು ಇನ್ನೂ ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಈಗಾದ್ರೂ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಮದುವೆ ಮಾಡ್ಕೊಳಂಗಿಲ್ಲ, ನಾನು ಮಗುವಿನ ಜೊತೆ ಇರ್ಬೇಕು. ಈಗ ಆತನಿಗೆ ಈಸಿ ವೇ ಮಾಡೋಕ್ ಸಂಬಂಧಪಟ್ಟ ನಂಗೆ ಡೈವರ್ಸ್ ಕೊಡೋದ ಒಂದೇ ರೀಸನ್ ಅಂತ ನನಗೆ ಕೇಳಿದ್ರು ಅವರು. ನನಗೆ ಅಲ್ಲಿ ಆಫೀಸ್ ನಲ್ಲಿ ನಾನು ಟ್ರೈ ಮಾಡಿದೆ, ಏನ್ ಮಾಡ್ತೀರಿ ಇಷ್ಟು ಫೋರ್ಸಿಬ್ಲಿ ಅದ್ ಜೊತೆಗೆ ಇದ್ದು ಏನ್ ಮಾಡೋದು ಅಂತ ನಾನು ಕೇಳಿದಾಗ
ಒಲ್ಲದ ಗಂಡನ ಜೊತೆಗೆ ನಾನು ಇರ್ತೀನಿ ಅನ್ನೋದು ಏನ್ ಸೂಕ್ತನಮ್ಮ? ಸರಿ ಆಯ್ತು.
ಮಗು ಆಗಿ ಕನ್ಫರ್ಮ್ ಆಗಿ 15 ದಿವಸಿಗೆ ನೀವು ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕಿ ಜಗಳ ಆಡಿ ಆಮೇಲೆ ಇಲ್ಲ ನೀನ್ ಬಿಟ್ಟೋಗಿದ್ಯಾ ನಿನ್ ಕಾರಣ ಮತ್ತೆ ಇಷ್ಟು ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಮಗು ಯಾಕೆ ಟ್ರೈ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಸರ್? ಇಷ್ಟು ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಮದ್ವೆ ಯಾಕೆ ಆಗ್ಬೇಕಾಗಿತ್ತು? ಇವೆಲ್ಲ ಬ್ಲೇಮ್ ಹಚ್ಚಂದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ ಅದರ್ ವುಮೆನ್ ಆಲ್ಸೋ ಟು ಜಸ್ಟ್ ಗೋ ಲೈಕ್ ದಟ್. ಅಂದ್ರೆ ಹಿ ಗೋಸ್ ಸ್ಕಾಟ್ ಫ್ರೀ ನಾ ಸರ್? ನಮ್ದು ಅಂತ ಲೈಫ್ ಇಲ್ವಾ ನನ್ಗೆ?
ಆಯ್ತು, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. We will consider. Yes.
Seal number 21, final hearing matters, Ashokar Kalyan Shetty.
It may be taken as for the appellate.
Well, matter ಇದು national highway matter ಸ್ವಾಮಿ. Now lords have heard that national highway is not liable to satisfy the award amount. It is only the state government. Inconvenience.
ಇದ್ರಲ್ಲೇ ನಾವು ಆರ್ಡರ್ ಪಾಸ್
ಹೌದು, first order is in this.
So we'll have to proceed.
To hear the appeal on merits. Some
It's come up for final hearing.
ಹೌದು, ನಾನು just to refresh my lordships ಅದನ್ನ ಹೇಳಿದೆ. Lords ಅವ್ರಿಗೇನೋ
Next week, government advocate will argue the matter.
ನಾನು ಒಂದ್ ಸ್ಮಾಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಬುಧವಾರಕ್ಕೆ ಇಟ್ಕೊಳ್ಳಿ. ಸ್ವಲ್ಪ ಬುಧವಾರಕ್ಕೆ
ಅದೇನು
ಅಲ್ಲ, ಬುಧವಾರ ಅಂದ್ರೆ ಮಂಡೇ ಐ ಆಮ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಫಾರ್ 2 days. So I have some inconvenience since the matter is also.
5ನೇ ತಾರೀಕು ಹಾಕಿದ್ರೆ ಪರವಾಗಿಲ್ಲ.
After Monday, any day.
Thursday,
Friday.
At the request of learned government advocate, release this matter on 5th of December.
Please.
Seal number 22, GB Yadav. 22.
Yes.
GB Yadav, seal number 22.
Matter is called out. There is no representation for either of the parties. Stop. Release this matter on 5th of December.
Seal number 23, additional SPP. 23.
ಅವಿನಾಶ್ ಉಪ್ಲಾಂಕಲ್ ಅವ್ರದ್ದು ತಾನೇ ಮೊನ್ನೆ ಇದಾಗಿರೋದು. Release this matter on 9th of December.
Seal number 24, additional SPP.
ಅಲ್ಲ, ಅದು 9th ಬೇಡ, 11th of December.
24, additional SPP.
Release this matter on 11th of December.
25, Basuraj Kareddy.
Your Lordship, bring for the respondents, Your Lordship. Your Lordship, kindly a week's accommodation, Your Lordship. I have informed the other side, Your Lordship, in the morning. It is regarding a land losers scheme appointment, Your Lordship.
Court notice, ಅದೇನ್ ನೋಡ್ರಿ?
That is regarding the appellants not appearing for the proceedings, Your Lordship.
Who not appearing?
The appellant counsel, your lordship. That notice was regarding that one.
Ah.
Yes. In fact, he was present on the last two occasions, your lordship, but the matter could not reach. But today, we have informed him that we will seek a adjournment. It will inconvenience your lordship.
He was present on the previous occasion, is it?
Yes, he was present, your lordship, but the matter could not reach on that day. So it was urgent. But today we have informed him.
He has informed you.
No, we have informed him on the call, your lordship, that we will be seeking an adjournment today.
Learned counsel for the respondent submits that the learned counsel for the appellant was informed that an adjournment will be sought. Full stop. Next para. Release this matter on 5th of December.
Published. Yeah. Published.
Seal number 26, Manvendra Reddy.
No representation for either of the parties. 5th of December.
Seal number 27, Mahantesh Patil.
Same order.
Seal number 28, Shvi Desmukh.
Same order.
Seal number 29, Rajendra C. Desai.
At the request of learned counsel for the appellants. Release this matter on 5th of December. Yes.
Seal number 3030, Vinayak Apte.
Appear for a petitioner on behalf of Vinayak. Next week, my lord. Next week, my lord.
At the request of learned counsel for the appellant, release this matter on 5th of December.
Published.
Seal number 31, additional SPP.
At the
31.
request of the learned additional SPP, release this matter on 5th of December. Yes.
33, Shivkumar Kallur.
Hey, iವ್ರಿಗೆ respondents will have to say no representation. Huh? 31 ಅಲ್ಲಿ ಇಲ್ಲ all the three are served ಅಷ್ಟೇ. So we'll have to appoint an amicus. ಹೌದು. ಹೌದು. Correct. ಕೊಡಿ dictation ಕೊಡಿ.
Despite issuing the notice to the respondent, one and two.
To the respondents and
To the respondent, remained absent and unrepresented. The trial court has acquitted the accused for the commission of offences and section 498A, 302, 303, dismissed. Section 34 of IPC, section 304 of WPI. Considering the seriousness of this offense, it is necessary to issue bailable warrant to the respondent for rupees 10,000 each through concerned police.
Returnable by. Returnable by.
Bailable warrant returns by
12th of December.
To prosecute this case on what?
CL number 33, Sukumar Kalur. 33.
Matter is called out. There is no representation for the respondent. Release this matter on 5th of December.
CL number 34, Sharan Basappa K. Bab Shetty. 34.
No representation for either of the parties. 5th of December.
CL number 35, Ravi B. Patil.
Kindly short accommodation may be granted, Your Lordship.
You are appealing to the appellant.
Please.
At the request of the learned counsel for appellant. Release this matter on 9th of December.
CL number 36, Ravindra Reddy.
This matter, my lord, my writ petition has been allowed, my lord, and the government has been, my lord, the liquidation.
Well, in friend ilvala.
ಮೊದಲು appear ಆಗಿಲ್ಲ ಅವರು. My lord, even on the last occasion also, my lord, and my lord, here my writ petition is allowed, my lord, directed, my lord, the KPT cell has been directed to, my lord, appoint me. And my lord, even they have taken a decision, my lord, in the board headed by Chief Minister, my lord, even to appoint me. Even thereafter, my lord, this appeal is pending. And my lord, now, my lord, they need to comply with the order of the
Have it
Lord.
on Monday.
Please,
Monday.
please.
Matter is called out. There is no representation for the appellant. Release this matter on 2nd of December.
Please.
Please inform him.
Please.
Yes.
CL number 37, Ganesh Subhash Chandra Kalaburagi.
No representation for either of the parties. Release this matter on 9th of December.
CL number 38, Government Advocate.
Matter is called out. There is no representation for the respondents. ನೀವಿದ್ದೀರಾ?
Yes.
ಯಾವ್ದ್ರಲ್ಲಮ್ಮ?
38.
38
Sachin M. Mahajan.
Sachin Mahajan. Yes.
My lord, AG will argue the matter, my lord. Already citations has been given, my lord.
ಯಾವ್ದಿದು?
38 only. Long back citation ಕೊಟ್ಟಿದೆ. AG will argue the matter.
ಅರೆ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಅಂದ್ರೆ ನಮ್ಮ ಮುಂದೆನಾ? ನಮ್ಮ ಮುಂದೆನಾ?
Single bench,
my lord, it was, now, my lord, we have to refer that those documents, my lord. We also have it on 11th, my lord, on that time, my lord, will. 12th.
After 11.
12th act.
At the request of the learned government advocate, release this matter on 12th of November or December.
Please.
CL number 39, Sachin M. Mahajan.
ಏನಮ್ಮ ಅದರ್ ಸೈಡ್ ಯಾರು ಇಲ್ವಲ್ಲಮ್ಮ?
Sir,
ಹಾ
ಯಾರು ಸರ್ ಆಗಿದ್ರು ಮೇಡಮ್.
ಅದೇನೆ. So you have no opposition.
ಸಪೀರ್
Your petition has been dismissed.
dismissed ಮೇಡಮ್. On ground that durability.
You want to argue the matter?
One next week.
Your petition has been dismissed. Other side is served unrepresented. February 2023,
Yes,
order has been passed that served ಅಂದ್ಬಿಟ್ಟು.
sir.
ನೀವು ಅವಾಗ್ಲೇನೆ ಮ್ಯಾಟರ್ ಮಾಡಿ ಮುಗಿಸ್ಕೊಡ್ಬೋದಾಯ್ತು. ಸುಮ್ನೆ why you want to keep this matters pending like this?
Client seeking a divorce.
Huh?
She is seeking a divorce.
There is a female child.
Yes, one daughter.
Huh?
One daughter.
What is your contention?
The respondent also remarried.
Hmm?
He is remarried. He is remarried.
Remarried.
Oh. Respondent.
Yavaga?
1 year back.
That has happened after the appeal is filed.
Yes.
Huh?
1 year back.
ಸರಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ ಯು ಪ್ಲೇಸ್ ದಟ್ ಮೆಟೀರಿಯಲ್ ಇಫ್ ಯು ಹ್ಯಾವ್ ಎನಿಥಿಂಗ್.
Yes. On one date.
Huh?
One date maybe.
Learned counsel for the appellant submits that the respondent has married another lady during the subsistence of the marriage with the appellant. Full stop. Learned counsel seeks for a short accommodation to place necessary material before this court. Full stop. Release this matter.
Monday.
5th ಆಗ್ಬೋದಾ? Huh?
Yes, please.
On 5th of December.
Seal number 40, additional SPP. 40.
Release this matter on 10th of December.
Seal number 41, HP Desmukh.
The appellant, my lord.
Yes.
This is an appeal against the trial court decree of declaration, my lord. The appellants were not made party to the trial court proceedings. That was a collusive suit between unknown persons, my lord. Completely unknown person to the suit property, completely unknown person to the family of the appellant. They have filed a suit before the trial court, seeking declaration that they are the owners of the suit.
You are not parties to the
Not part,
suit.
not part.
So you have filed this appeal
That is,
along with an application to
yes, prosecution.
prosecute.
That was allowed.
It was allowed. Order ಆಗಿದೆಯಾ?
I am the plaintiff.
Huh.
Under order 12, rule 6.
Huh?
Under order 12, rule 6.
On the
Decree
basis of
again.
the admission made by the defendant before the trial court has decreed the suit on the base, under order 12 rule 6 of the CPC. ma'am.
Oh.
That is my contention because it is not binding on me and they are complete strangers to the suit property. So on that basis, I have filed this appeal, my lord. And
You are
trial-
ready? Huh?
No, sir.
ಅಲ್ಲಮ್ಮ ಆ ತರ ಆದ್ರೆ if plaintiff is able to obtain a judgment at the saying of the defendant conceding, then naturally some person who's going to be affected by that decree is before this court.
They are not filed even genealogy also.
ಹೌದಾ? ಅಲ್ಲವಾಗಿಲ್ಲ ರೀ.
I-1 of additional document, ma'am.
Additional documents ಅಲ್ಲ, your application to prosecute the matter is still not allowed. It
Special leave ಆಯ್ತು. To initiate this appeal. ಅದು ಒಂದು rule change to include as a dependent.
Please.
ಅದು that is
I apologize, man. I thought it was allowed and I have also filed an additional document. I thought that was not, that was to be considered.
You have also filed an application
For
under
additional.
order rule 1, order 1 rule 10,
Please, man, please.
Year number 4/2020.
Yes.
Prosecute the appeal.
that is allowed,
That is all.
Whether
That is
you
allowed.
filed application order 1 rule 10 to implead as a party to the suit.
Illa, my lord, I have filed an additional document. There are 3 IAs, my lord. One is permission to prosecute. One is stay, that was allowed. And another one IA is for additional document.
ಅಷ್ಟೇ ಹಾಕಿರೋದು.
Yes.
Must have not filed the
The contention is that they should have made me a party. They have not made me a party, so therefore this decree has to be set aside for directing them to implead me as a party. I am not going to file an application. It is for them to file an application. That is the contention.
So
We'll allow it then.
On Monday,
Huh?
Monday.
Additional documents. ಏನ್ documents?
My lord, I have produced the documents with respect to my claim over the suit property that one is my mutation made by the Tahsildar, another is my genealogy. And I have also filed the application before the Tahsildar, my lord. And then the land which was given to my ancestors, that Hakku Pata was also.
ಇದೆ.
Yes.
ಬಂದಿದೆ.
suppress ಮಾಡಿ ತಂಡ.
ಅದೇ.
Suppress ಅಂದ್ರೆ completely collusive suit, my lord. Plaintiff ಹಾಕುತ್ತಾರೆ, immediately written statement ಹಾಕಿ I concede to the grounds urged by the plaintiff and the suit may be decreed and the written statement ನಲ್ಲಿ admission ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.
RPC ಹಾಕಿಲ್ಲ.
My lord,
RPC
ಏನು ಹಾಕಿಲ್ಲ, my lord. If the lordship peruse the judgment, my lord, of para number.
Document ಇಲ್ದೇನೆ ಆಫೀಸ್ ನಲ್ಲಿ ರೈಟ್ ಮಾಡ್ಬೇಕು.
ಸರಿ. Judges ಹೇಳಿ. We can't solely depend on office raising of this.
ಅದು ಆರ್ಡರ್ ಫ್ರಮ್ ಫಿಕ್ಸ್ ಆಗಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಟೇಕ್.
Should be more careful.
If lordship peruse the para number 7 of the OS judgment at page number 13, my lord. The reasoning given by the trial court is only that as per death certificate, he died on so and so. Therefore, on perusal of the
RTC
entire.
extract ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ.
My lord.
Paragraph number 7 ಅಲ್ಲಿ.
Yes, RTC extract ಇದೆ.
On perusal of the entire pleadings, RTC extracts ಅಂತಾರೆ.
RTC extract ನಲ್ಲಿ the name of the Shah Abdul Razak Shamsuddin some person's name was shown, but they have not proved any relation with that person. Only their certificate has produced. That person is my great grandfather. Appellant's great grandfather. Only on the basis of death certificate they have allowed the claim.
We'll allow.
Let them serve a IS copy, Your Lordship. They are not even served the copies of the IS of the additional documents, Your Lordship. We will argue on merits on Monday, Your Lordship.
Monday.
Monday.
ಕೊಡ್ರಿ ಅದೇನೋ ಕಾಪೀಸ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಪ್ಲೀಸ್. Learned counsel for the appellant. He is requested to serve copies of the IAS on learned counsel for the respondents. And list this matter on 5th of December.
And one contention, my lord, I am sorry, I have forgotten earlier mentioned, my lord. When the notice was first issued, the respondent remained absent. There was an observation by this court that even though the service notice was served, they remained absent. So whether it will be considered as an ex parte or because they have filed an vakalata afterwards, my lord. Only recently.
That's all right.
Please.
That should not stop the court from hearing them.
Please. Please.
At best, we can only impose costs ಅಷ್ಟೇ.
Please.
That is not going to serve the purpose. At 2:30 PM, we'll hear this matter and dispose of.
And there was an
December.
interim order may kindly be extended.
Interim order granted earlier stands extended till the next date of this. Obliged.
But 17 and 35, my lord, I am ready in both matters. Be taken, my lord, since I was stuck in other court, my lord, they are urgent. Ready in both matters.
We have given dates. We have given dates.
Date.
Huh?
5/12, date has given 17.
26, my lord. Another court.
Monday.
Then, Monday have it on Tuesday.
ಎಲ್ಲಾದ್ರೂ dates ಕೊಟ್ಟಿದೀವಿ.
Tues-
We have not,
I'm ready, we are ready, my lord, on Tuesday, instead of Monday, Tuesday.
Monday ಅಂತ ಹೇಳಿದೀವ.
Monday.
Monday.
On the other side.
Mahesh Patil, I'll.
ಆಯ್ತು.
17.
ಯಾವ್ದು serial number?
36.
You want it on Tuesday, 3rd of December.
17 ದಲ್ಲಿ interim order expire ಆಗುತ್ತೆ.
Interim order extend ಮಾಡಿ. Yes. Yes.
ಇನ್ನು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ 36 ಎರಡು ಅಂತ ಹೇಳಿ ಅವನು